I'm Michael Stanley. I am the lead organizer for Manhattan Together and South Bronx Churches, and Sara and I will be sort of switching off as we're talking. SBC and Manhattan Together are affiliates of the Metro Industrial Areas Foundation, which are groups of congregations and community-based organizations that have been working in metropolitan New York for about 40 years, helping to build thousands of units of affordable housing, starting new schools, helping and pushing, police to do a better job and making communities safer and fairer for everybody. And on and off for that entire time, and pretty much continuously since the year 2000, we've been dealing with what I think everybody knows now is one of the greatest failures of local government, which is the New York City Housing Authority. As you know, that's something that is now getting a lot of coverage, but didn't, say in the year 2000 when we started this latest iteration. And we've basically got into this because thousands and thousands of members of our congregations and other organizations lived in NYCHA apartments, and they were dealing with, faulty elevators, lack of heat and hot water, pest infestation, lack of safety, and as another major area we're going to talk more about, leaks and that led to mold, which exacerbated asthma, and many, many other things. As you see, one of the apartments that we helped to find right there. We've been organizing, and we basically, the tenant leaders would knock on their neighbors' doors. They would document problems, take pictures, report them, and we would met with local officials all the way from local property managers up to the NYCHA chairperson, and then deputy mayors and everything else. And we were able to get thousands of repairs that way, but it all was illustrated, to my mind, in a story from one of our main leaders, Father Frank Skelly, who's the pastor of Immaculate Conception Church in the South Bronx. It's 150th and Melrose. And he told a story about going to a NYCHA development with one of his parishioners, and this was one of the many times when they claimed she had not paid rent that she paid. And her English was not fabulous, so she went with Father Skelly, and the secretary, treated them both with just an intense amount of hostility. And eventually they were able to raise enough of us that the manager came out. And the manager saw Father Skelly and said, "Oh, Father, we didn't know she was with you. We're so sorry." And he said, "Oh, so if she hadn't been with me, this would be fine. But because she knows me, it's a problem." And essentially what we were able to do throughout certainly the first 11 years of this process is we were able to help the people who know us to have a chance to at least receive barely mediocre service, where they had a decent chance of getting, like this woman's, after having to go through all its rigmarole, her situation was fixed. And we were able to get many places like that, fixed and resolved. But obviously knowing us or knowing any other organization should not be what it takes to be able to live in an apartment that doesn't make you sick. And more to the point, even knowing us was not a guarantee by any stretch of the imagination. We also are an organization that's been around in New York City for 40 years and nationally since 1939, so however long that is. And we've tried to avoid litigation throughout most of our history. Most of you, I believe, are attorneys, so I think you probably know why we tried to avoid litigation for most of our history. But we had our sister organization in New Jersey had a great experience with NRDC on a case of hexavalent chromium, dealing with hexavalent chromium, and we realized that the strategies that we'd been trying, we'd gotten as high up as we could go. We'd met with Mayor Bloomberg and his deputy mayors and other folks several times, and it just wasn't getting the job done. And so we talked to NRDC about, well, can we look at some kind of legal strategy to pursue, with all the trepidations that came with that. And then Sara will take it from here.
Yeah, thanks everyone for being here. And do you want to, we have a few pictures. Basically, these pictures are up here. They're just photographs naming the NYCHA development and the year the photo was taken. And we do this in our presentations because sometimes we say mold and people imagine like what lives in the corner of their shower if they haven't cleaned it for a little while. And when we're talking about the mold crisis in NYCHA housing, we're talking about health-threatening, extensive mold and moisture problems. I also want to just thank Rachel for starting the presentation off that way. It will become apparent through this whole story that no part of this case would exist but for our organizers and clients. Inherent to community and environmental justice lawyering are the ideas that frontline communities speak for themselves, that they know what justice looks like and they can define it for us just as well as any lawyer can. And that process is as key as the outcome. And I hope that we have built that over the course of the many years that we've been working on what is becoming a long-standing stint of litigation. And so like Mike said, we were approached in 2011, is that right? In 2011 by some community organizers associated with Metro IAF, Manhattan Together, and South Bronx churches, and also a group called Little Sisters of the Assumption Family Health Service. And they came to us and kind of said, so we've been doing this for decades. There are a lot of problems in NYCHA housing. We can kind of organize and we'll get developments organized and neighbors will really kind of like put a ton of effort in and get to know each other and really amplify the issue, and we'll get it up to a certain level in terms of the NYCHA bureaucracy. And then we hit a wall. Either it can't go any further, it doesn't extend beyond the group of people we brought. Inevitably, the NYCHA person that they were having success with would be fired or moved or transferred, or something else would happen kind of in that process that would just require them to start over. A lot of tenants were bringing their claims to housing court and being successful, and then finding when it was time to force NYCHA to make the repairs that no one would be able to enforce that. Housing court simply could not keep up with the volume of these things. And so they came to us, and that's kind of how we love to do our EJ cases, when the community shows up and knows what they want to prioritize and has a really great sense for kind of the community and the history, and we get to plug in and serve them in their power building and organizing. And so we got to thinking, like someone earlier on the panel mentioned, a lot of environmental laws don't touch this kind of like disparate impact civil rights narrative that's so central to so many environmental justice issues. And so we were like, well, the mold is really kind of jumping out at us as a very serious and like apparent problem. And it was across all of the boroughs, in all types of developments. And asthma, as you saw from some of the maps that Rachel was showing, there's a lot of overlap between low-income communities of color and asthma prevalence and housing in need of repair. And so someone wrote a memo talking about the Americans with Disabilities Act, and we were kind of wondering out loud to ourselves, is asthma a disability? Is breathing one of those major life activities that's protected under the ADA? Turns out the answer is yes. And so we approached Manhattan Together and South Bronx churches with this kind of possibility that the ADA could be our vehicle. And it could be our vehicle because so many folks in NYCHA housing suffer from asthma. A lot of children suffer from asthma in ways that means they miss school because of hospitalizations, because the healthcare system isn't great and doesn't have a perfect safety net built in. A lot of times it meant exclusively going to emergency rooms to deal with their asthma. And so we kind of latched onto that as the idea to move us forward, and it would get us in federal court. It's a federal law. We could talk about the civil rights narrative that's central to it. It is a civil rights law after all. And it would allow us to kind of think about systemic change in terms of NYCHA, so they wouldn't have to do this person by person, apartment by apartment strategy. And And like you've heard from a lot of folks tonight, it was kind of are we really going to litigate this thing? Knowing full well that like it's a lot of time and work, and quite frankly, to kind of what ended up being our kind of settlement with the New York City Housing Authority turned into a systemic approach, but the ADA is really built to deal with individuals' needs and individual disabilities. And so to kind of build the case required a lot of just visits with tenants in their apartments to get to know them, to go through the stack of terrifying paperwork and waivers that we needed everyone to sign before we could send a note to their doctor talking about their asthma, before we could get their tenant files. And that part would not have happened but for showing up at people's doors with Father Skelly or Pastor Getty or Ray Lopez or Mike Stanley here. It's a very intimate thing to show up to someone's apartment in which their children are home. They're going to talk to you about the fact that they're really embarrassed that their apartment is unsafe and uninhabitable and that they feel like they don't have any power. And so that was kind of how we built the case. We went apartment by apartment, talked to folks. We wanted to make sure we were protecting tenants and weren't putting anyone who might be vulnerable to retaliation in front of NYCHA for this. We needed to make sure that we were amplifying people who had experiences with asthma, meaning they had been diagnosed, which is sometimes a hurdle for folks. And we kind of put it together that way, starting by making requests for reasonable accommodation under the ADA. So that meant sending a letter to officials at NYCHA saying, I have asthma, this is a disability, you have to tell someone about your disability. We included pictures and doctor's letters. And then we kind of waited. We were like, how much time? Is there something baked into the law for how long you're supposed to wait for a response? And we couldn't figure that out. And so we were like, a lot of these environmental laws have a 60-day kind of notice baked in. So we'll wait 60 days. And NYCHA never responded. They not only didn't respond, they later told us no one ever saw them, received them. So that kind of set the tone for how things were going to move ahead. And so we were ready in 2013 to file this complaint.
June of 2013. Right?
Yeah. And then Mayor Bloomberg's office kind of stepped in. And do you want to talk about?
Yeah. So the mayor who had, made a bit of a name around public health and everything, didn't love the idea of being sued close to his way out the door for helping to make poor children very, very sick, and therefore entered into some pretty heavy and intense negotiations for a very, very long time, and it stretched out until December of 2013. Just before he was out the door. And part of the context of this was that, it said that initially NYCHA was not in the news as it was. Part of how we got it in the news, obviously we're doing this kind of work with NRDC and other folks, but the reporter by the name of Greg Smith from the New York Daily News, who, if you all are not familiar with his stuff, you should be reading it. And my boss was at the Daily, we had a long-term relationship with the Daily News, and we were working with them to organize these mayoral candidates forums for the 2013 election. And he happened to be there, and Greg was doing some research about police officers who'd been shot in places in NYCHA where there were supposed to be cameras, and the money had been allocated for cameras, and of course NYCHA never, saw the money and never built the cameras and never installed the cameras. And so he said, "Yo, do you know anything else about NYCHA?" And said, "Oh boy, do we." And Greg started digging into this like a pit bull and started pushing all of this, and he was on the cover of the Daily News all the time, and we just had reams and reams of documentation, and then throughout all of 2012 there was just one story after another, because we could introduce them to people, we could show everything, and that created a real pressure. And the combination of that, and we had these 3 mayoral forums with thousands of people. First one was on housing, and that really helped to further propel this into the limelight. And that created, Dateline NBC also did a big story about it. And so it was the combination of the media pressure, the work with the elected officials, that created the incentives for the mayor's office to put the hammer on NYCHA to settle and finally issue a settlement December of 2013.
Yeah, so we were feeling at first kind of like bristly towards this idea of settling with NYCHA, that they had kind of shown such disregard for so many tenants for so long, the fact that they kind of ignored our request for accommodation. We didn't really feel like that was going to go anywhere. But this pressure from the mayor's office, I think, really helped shape the narrative moving into the negotiations. And like Mike said, for I think over 6 months, they were ongoing. And we ended up coming to an agreement. NRDC and our clients knew that there were certain things that we just required in this agreement before we would feel comfortable. One was that it would be court enforceable for a certain period of time. We kind of saw coming that maybe they weren't going to do everything that they had agreed to.
Or anything.
Another key piece was that we would be prioritizing our named plaintiffs, making sure that they were getting their apartments fixed, and also that that we would be getting kind of benefits for all, that this wouldn't just be a one-off talking about requests for accommodation for every single tenant who wanted one, but rather that we would talk about really changing NYCHA's mold and moisture policies across the board, really updating their strategies under the ADA, and taking this into a class action. So that initial settlement agreement required NYCHA to address the underlying causes of mold. In a lot of instances, when they would get a mold work order, what we saw happening was, one, no one showed up. Two, if they showed up, they denied that it was mold. If they acknowledged it was mold, they blamed the tenant for creating a situation in which mold developed. And if they decided they'd actually try to do something about the mold, at best it was scrubbing it or scraping it and painting over. At no point were walls being opened, pipes were not being dealt with. Despite the fact that in many developments we were seeing kind of issues in the same number apartment on each floor, like it looked very clearly to us as non-infrastructure experts that there was like a pipe break in one of these walls and it was affecting all of apartment number 6s in this building. And so that was a key piece of it. Improving the ADA policies and reasonable accommodations for asthma. There was no documentation on anything that NYCHA put out that acknowledged that asthma was a disability or that there were reasonable accommodations available for folks suffering from asthma. And so we updated those kind of documents and guidelines. Another important piece were quarterly reports that they had to give to the plaintiffs, kind of tracking all of the mold and moisture work orders that came in, and importantly, the reoccurrence rate after they claimed to have fixed a problem. And they were also put against timelines to fix problems. So there was a structure set up whereby they were supposed to do simple repairs, and simple and complex just denotes what type of kind of maintenance worker or expert came to the apartment. So like whether there was a painter or someone who could break the walls or someone who knew pipes. So simple repairs were supposed to be done in 7 days and complex repairs were supposed to be done in 15 days. And so that settlement along with a complaint was filed at the end of 2013, entered in early 2014, class established at the same time. And so we kind of went into like, let's see what happens mode. And it quickly became apparent to us through the diligent and ongoing work of Mike and our other community organizers that NYCHA was not complying with the settlement agreement. Do you want to talk about that a little?
Yes. What they tended to do was either totally maintain their operation, or it is much less frequent, although after that it was much less frequent, that they just simply didn't show up. But so they would show up and either lie and claim there was no mold, or simply paint over it. Sometimes they actually stopped the scraping and started scrubbing, which is worse, as a way to try to cover it up more frequently. It was interesting is, in this period, there was briefly an executive vice president by the name of Carlos Laboy Diaz, who seemed to understand that his agency was in peril. And the issues that we brought to him in the Bronx and Manhattan and in Brooklyn, he dealt with relatively quickly. But he then was fired. And we were actually told by Shola Olatoye that he was spending, who's now leaving, that he spent too much money on repairs. And that was why he was let go. So that was basically the tone for what we saw. Shola Olatoye is the now past director, past chairwoman of NYCHA. So that was the tone for the first couple of years of their honoring the settlement.
Yeah, so we kind of let that go for a little while. Mike and the other organizers were doing their regular diligence and kind of tracking all of this.
And doing meetings.
And organizing. Mm-hmm. And we decided about a year into that we really needed to start thinking about what a motion to enforce would look like. Thankfully, around this time, because the initial settlement had really kind of garnered a lot of press attention, thanks again to the organizers for kind of consistently keeping it in the news. So firm Hogan Lovells approached us about offering pro bono support, which now moving forward, I think we can't imagine continuing to kind of keep this enforcement effort up with just the initial party. So they've been central to it, and throughout it's kind of switched firms. Quinn Emanuel was involved with the most recent iteration.
That's really because of particular attorneys.
A particular attorney who've been moving.
Yes, moving around. Two particular attorneys who've been moving.
Yeah,
yes.
But they have stayed with us kind of throughout, and it's been personally one of the most fulfilling and best pro bono experiences I have ever had. They've been incredible. And so we thought through this kind of initial motion to enforce. It required essentially training some of the law firm staff, developing bilingual, science-based intake forms so that when we went to people's apartments, we could kind of track what was happening with the mold and moisture in their apartments, compiling data and tenant affidavits to counter what we thought would be NYCHA's narrative. And we kind of put all that together, and in summer of 2015, we made our motion, and we asked the judge to appoint a special master. And the judge found in a very compelling 8-page order at the end of 2015 that NYCHA had been out of compliance with the initial order from the day it was entered by the court, and that we needed a special master to make sure that NYCHA was doing what they were supposed to do. So our special master in this case was appointed in early 2016, and for the last 2 years, we have been working with that process. This is kind of getting us to the point now where you feel the litigation starting to drag. And quite frankly, it felt that way to us too, even as the lawyers, because you're in these meetings that are scheduled every few months and they go for hours, and you feel like we're just talking to each other and nothing is happening in the outside world. And not only were Mike and the other organizers doing nonstop outreach, quite frankly, NRDC and our other partners, NCLEJ, were getting cold calls constantly from tenants all around the city who would Google mold in NYCHA, and we would pop up in our membership department would get cold calls that they would then file to me. And I would have to tell folks, I could put you on the list that our organizers are working through to elevate to NYCHA, but I can't individually promise you anything. We're working on a systemic process that's moving very slowly, and I am so disappointed that I can't do something more immediate for you. And it got really, it was terrible to have to say that kind of every time someone called you. And that was a really kind of difficult period where you recognize that the special master has been appointed. That looks like a victory on paper. But quite frankly, a victory in court isn't always a victory on the ground in an immediate way. And so, yeah.
Okay. And what this, what myself and Father Skelly and Reverend Getty Cruz and Ray Lopez and all the tenant leaders folks, what we were seeing on the ground is, unfortunately, in many cases, the problems continued. This is from 2017, long after the special master was appointed, but we did see some improvements. And so, for example, but this is, to a certain extent, I almost hesitated to include this, because we're talking about, in Manhattan and the Bronx, we're tracking 669 apartments. In roughly 350, there's some improvements that were dealt with. This is one of the more dramatic ones in the Morris houses, where I was in there, and looked like mold. We reported it, and just a few days later they came in and really seemed to have dealt with it quite well. This came from the process of a continued process added to, of what we described before, added to the fact of relationship with the court, and so in addition to media, elected officials, everything else with the court. So basically what we were able to do was, they said, if you know us, you stood a better chance of getting a decent report. We got to a point where we increased the chance of knowing us meaning something, and got to know some more people. So good for those who knew us, but deeply, deeply unsatisfying, and to a certain extent infuriating overall. And frankly, though, while some of the repairs looked like this, many of them looked like that as a result. And you can see cracks in the walls and everything else, and things would come back quite frequently. And then unfortunately, this was just taken a couple of weeks ago. Fortunately, many places still looking like that, and that's even of the places that we're in touch with, which is why we're pushing on a number of different angles for this, and both in the legal strategy and outside of it. And the settlement, there are certain aspects of the settlement that Sarah's going to talk about that we've been, a new settlement agreement that we reached with NYCHA, that are critical to us to see, at least to get some of the benefits beyond the relatively small group that knows us.
Yeah, so I think we're almost at the end of our time, but really quickly, to Mike's point, it's just, sometimes we were seeing improvements, but for the most part, it required extensive hand-holding from our organizers. And so
I would call it trench warfare.
Warfare or hand-holding from our organizers. And that's just not a sustainable system for a housing authority like NYCHA, where we have nearly 500,000 folks living in NYCHA housing in New York City. And so throughout the kind of 2 years of the special master's tenure, we were kind of leading up to this idea that we needed to revise our settlement agreement to include some new terms. And so that was actually just filed for the judge's approval in early April. And it includes several provisions that, now that we've kind of learned this process better over the course of the last several years, we are